All right, good morning, everybody. Thank you so much for joining us this morning. The meeting is being recorded, and a copy of the recording as well as the slides will be made available on our website within a day or two after this presentation. Some of you may have noticed that this isn't the normal time of the month that we do our monthly webinar. This is not our February webinar. We will still be having our webinar next week, Thursday at 10 o'clock, where we will be joined by Mr. Mike Murray of Pam Golding Property Management Services, where he'll be discussing financial management in community schemes, which Annette has pointed out a couple of minutes ago might be the reason that our numbers are not looking that great this morning. Everybody is hard at work preparing for budgets and annual financial statements and all the upcoming annual general meetings. I spoke to a colleague of mine a couple of days ago, and she said that since the year has started, she's already hosted almost 100 annual general meetings. I don't even know how that's possible based on the number of days and things that we've been working, but it's crazy how many meetings and things are taking place at this point in time. If you do have some background noise on your side, please do mute yourselves. Otherwise, you're more than welcome to stay unmuted. If you have any comments or questions, you're more than welcome to pop your hand up, pop them in the chat function. And then, of course, you can contact us afterwards as well. So the invitation today, sorry, I'm struggling to find my words. The invitation today for this webinar was sent out for the first time on our newsletter. We've posted 2 newsletters thus far, January and February. If you haven't received copies of those, you're more than welcome to pop me an email, and Nicole will share my email address in the chat function. And if you haven't signed up for the newsletter, please do so. The link is on our website under the tab blogs. Alternatively, you can pop me an email as well, and I'll send you that link. If you are not signed up for our newsletter, you will not be receiving correspondence from us. And as many of you will know, this is because of Poppy and Paya and all those fun things. We don't want to engage with anybody that has not consented to us engaging with them. So you have to, unfortunately, take those 30 seconds, sign up for our newsletter, and then only will you receive the information from our officers. If you, of course, are on social media, LinkedIn, Facebook, you'll still continue to receive that information there, but I know many of you are not. Otherwise, many of you prefer to keep your social media for your personal reasons as opposed to work-based, which is also 100% fine. For those of you that have a little bit of time, I know that it is very, very difficult to fit it in during your day. We are still running our poll on unanimous resolutions, especially aimed at managing agents and trustees. The aim of that is to see how many body corporates are not able to get a quorum for the passing of a unanimous resolution, that 80% quorum. The reason behind it is that we're trying to engage with the Community Scheme Ombuds Service to lower the threshold requirements for a unanimous resolution at a special general meeting or an annual general meeting, at least where an attempt has been made to get that unanimous resolution or quorum and has failed. I know in my experience, I have never been able to get a unanimous resolution passed at least the first time around because of that quorum requirements. So I'd also like to make use of this opportunity before I hand over to our guest to formally introduce Nicole Null. That's right, we have another Nicole on the team, not to be confused with the OG Nicole Tavares. Nicole Null has joined us recently, almost straight out of university with an LLB degree. She's joined us as a junior community schemes consultant, and you'll see a lot more of her on these webinars, in articles, and of course in our consulting department. So we'd like to extend a very warm welcome to Nicole, and I hope that she will be part of this family for many, many years to come. On that note, I'd like to introduce our speaker today. She's not a stranger to any of you, Leigh-Anne Harrison, Portfolio Manager at RPA Property Administrators, and of course, Legal Eagle herself, having practiced for a number of years in general litigation and sectional title. Leigh-Anne has got a passion for all things compliance and contracts, and she works with us very often as a consultant as well. Welcome, Leigh-Anne. If you can share your screen on your side, and then I'll hand over to you.
Thanks, Linda. A second. There we go. Okay.
Perfect, we can see that.
Okay, can everyone see that then? Linda, you can see that?
Yes.
Okay. Thanks, Linda. Thank you for that. Thank you for that nice introduction. I don't say that I possess all the skills, but legal is what I enjoy, and community schemes is what I practice at the moment. So I enjoy that I can combine the two. Linda asked me a few weeks ago to present on the Property Practitioners Act. And I think over the last, we're now not even towards the end of Feb, and it's just all over social media. There's webinars, there's articles. It's just coming out of my ears. So I'm glad I could present this morning. I don't say that I possess all the knowledge on this act. I've done some research, and this morning the aim of the presentation is just to give you an idea of how it affects managing agents. I'm not going to go into a lot of detail on all the points because I think we'd be until next week. So if there are any questions, you can pop them in the chat. I'll try to answer as many as I can. I know I joined a webinar about 3 days ago, and a lot of the questions were very technical, and even myself, I didn't feel comfortable answering them if I was a presenter at the time. So if there's any ones that I feel I might need a bit more time to research on, then Zelinda will take a record and then we'll answer them afterwards. But we'll endeavour to answer as much as possible at the end of the presentation. So then I will begin. As mentioned, we're talking about the Property Practitioners Act and how it affects managing agents, or the effect on managing agents. The act came into operation on the 1st of February 2022. And from what I've seen, prior to that, on the 14th of Feb is when the regulations were issued for this act as well. It hasn't given practitioners or anyone in the property industry a lot of time to work through the act. There's a lot of talk about contradictions from the regulations and the act. So at the moment, I think everyone is just trying to get to the basics of the act and apply it thereafter. What the act in effect has done, it has repealed the Estate Agencies Affairs Act. So it's now the Property Practitioners Act, and the Estate Agency Affairs Board has been replaced by the Property Practitioners Regulatory Authority. So same concept, different name. The Estate Agency Fidelity Fund was replaced with the Property Practitioners Fidelity Fund. And what happened was that when that took place, there was an instruction given, all monies currently in the EA Fidelity Fund had to be transferred to the Property Practitioners Fidelity Fund. It also means that managing agents are now regulated by a controlling authority, being the PPRA, Property Practitioners Regulatory Authority. And this is actually quite new because it's the first time in history that us as managing agents are regulated by a controlling body. So it's a legislative requirement that we comply, so it's a must. And as a result, it's very important that even myself as a portfolio manager and working for a managing agent understands the act, its regulations, and how we can comply. As it's a new act, I think it's going to take a lot of time for all of us to get to a point where we understand, we are compliant, and we can apply the act. So for now, I think it's best, we go through the motions, read as much as you can, attend a few webinars here and there, and then as well, ask Zelinda and her team any questions you have, and I'm sure we can get you an answer for you. I'll start with the first item on the act, how they define now a property practitioner. What they've done is they've introduced under the definition 4 new groups of a property practitioner, which now includes a managing agent. So if I look at the definition, it's any natural juristic person, natural being you and I, juristic being a company, a CC, a sole proprietor, who for gain holds themselves out to perform the following services: selling a property, letting a property, collecting or receiving money on account of a lease, like a letting agent, arranging finance, like a bridging finance or a bond originator, a property developer, most importantly for our purposes, a property manager, and then a trust where a trustee performs these services. There are a few other things that fall under this definition, but just for our purposes this morning, I included those. And if I refer to property manager, it also includes any person employed by a property practitioner to manage, supervise, or control the day-to-day operations of the business. So this would include a portfolio manager, a portfolio administrator, accounting, and HR staff. But as I will talk to later, there is some distinctions when it comes to who does this act sort of cover in terms of managing and controlling or supervising the day-to-day operations of the business. I will then move to the next slide. What's most important about the Act from our point of view is the concept of Fidelity Fund certificates and trust accounts. So it's mostly what I'm going to focus on this morning. What the Act has stated is that the Act now requires all property practitioners, and when I say property practitioner, I mean managing agent for our purposes this morning. So I'm going to use the words interchangeably, property practitioner, managing agent. The Act now requires all managing agents to apply for and hold a Fidelity Fund certificate. Just out of curiosity, I looked up the term, what is a Fidelity Fund? And it is a fund used to protect the public from an agent's misuse of trust funds. So we can trust money with somebody. So the Fidelity Fund is there to ensure that the money is kept safe. And what's very important here for our purposes is always to look at who has access to those trust monies. And that's what I'd like to ultimately get to part of my next slide. All managing agents now need to apply for Fidelity Fund certificate, and you do so via the new body, the Property Practitioners Regulatory Authority. The Act does specify how the application is made. I'm not going to go into detail, but it just advises that you need to apply for it via this authority. What I'd like to mention is that the Act refers to, under the definition, any person who manages a property. Thus, this applies to an individual. Thus, besides the managing agent who must apply for a certificate, it's the individual who will also need to now apply for the certificate. However, the distinction here is trust monies and who has access to trust monies. So the definition of a property practitioner refers to any person employed by a practitioner or managing agent. Thus, technically, all staff will need the certificate. However, if you look at access to trust monies, and I look at myself, don't necessarily have access to trust monies. I have potential access. My accounting team has access to the trust funds, my financial manager and the accountants. So the distinction always comes in when we're looking at if you need to apply for the certificate is who has access to trust funds or potential access to trust funds. The driver or cleaner of a business or a managing agent will never really have access to that information or have access to the bank account. So what the Act is now saying is only those who have access to or potential access, and that's very important, the potential access point, because I generally don't have access to the bank accounts. I instruct my accounting team to transfer funds where and when necessary. However, as a portfolio manager, it's one of my duties that I designate to somebody else. So it's always about who has access to these monies. And when you're looking at someone like the driver of your business or the tea lady or cleaner or even HR manager, you will have to apply for exemption for those staff members. So even if they don't have access to trust monies, they don't need a Fidelity Fund certificate. However, the Act prescribes that you'll still need to apply for exemption for these individuals in your company. So if you're employing a complement of 30 people, only 5 will have access or potential access to trust monies. The balance of 25, you will need to apply for exemption with the PPRA, the regulatory authority. So that's the important distinction here is who has access to trust monies, and if they do, they will need a Fidelity Fund certificate, and you apply for same via this regulatory authority. The importance of having a certificate is, when someone entrusts money with an agent, the fund via the certificate protects that person from the theft or loss of their money. This is, the same concept with the EAAB. So if you're running a trust account, you have to have a certificate because people are entrusting money with you. If there is no trust account, and some managing agents don't have trust accounts, you open a bank account in the name of the body corporate, you will not need the certificate. However, even though you won't need the certificate, you will need to apply for exemption. So any party, whether when you hold the trust account or you don't, you will still have to apply for exemption. It isn't automatic. There's an application to be made. The exemption requirements I'm just going to discuss later on in the slides. So it's important to come from this. Even if you don't have a trust account, and even if you don't have access to trust monies, you don't need a certificate, you still need to apply for an exemption in terms of the Act. It is I think it's a bit cumbersome, but this is now what's been introduced, and unfortunately we have to comply. I just want to discuss the distinction between trust and body corporate accounts. So many times, and even in our office where I work, we do hold trust accounts. We also open up bank accounts in the name of the body corporate. So it's not a trust account. Thus, if we were purely a business where we only had body corporate accounts, we wouldn't need a Fidelity Fund certificate. However, the question then is asked, but then if Fidelity funds protect trust accounts, how are body corporate accounts protected? And the answer is that in terms of the STSMA, when you have any monies held in account, you have to have insurance for that account, and those monies protected. So there's Fidelity Fund insurance, it's via your insurance policy and your insurance broker. So if you aren't sure, it's best to approach your broker and to ask them to confirm how much, or are you covered for Fidelity Fund insurance for risk of theft or loss of funds. So that's the distinction between the two. The next question that I picked up was, what about self-managed schemes and trustees who have access to scheme funds? So where you take the managing agent out of the equation, you've got a scheme that manages themselves. The question or the answer still comes back to, do those people have access to or potential access to a trust account? If they do have a trust account, those individuals will have to apply for Fidelity Fund certificate, or if not, they will still have to apply for exemption. With trustees who have access to scheme funds, if it's a trust account, same story, you'll have to apply for the certificate. If not, there's insurance to protect that account if it's a body corporate account, not a trust account, but you will still have to apply for exemption. So then I think the important thing to note is you'll always have, even if you haven't got a trust account, you have to apply for exemption. It isn't automatic. I suspect there'll be a few questions on this one, so I'll happily come back to this item, because when the last few webinars I've attended, this is a massive debate amongst all parties, not even managing agents. So I'll be happy to answer questions on this point. I'd like to go to the next slide. This is, how do you go about applying for Fidelity Fund certificate? In terms of the Act, you make application via the Property Practitioner's Regulatory Authority. And what's very important to note, which blows my mind, is that this authority has now advised that the authority has to issue a certificate within 30 days of application being made. They can request extension of 20 days. But if myself as a managing agent sends in writing a request, I need my certificate, they must give it to me within 10 days. Now, this is problematic because in the past, the EAAB took over 12 months to issue these certificates. And, in our offices as well, and many people I've met and spoken to, the same issue applies. Now, if they're taking so long to issue it, the old EAAB, industry experts have now said that, giving the EAAB a new name doesn't change the fact that the board was recently poorly managed. So actually, only time will tell how effective this clause will be, because it's creating a positive obligation on the PPRA to issue the certificates timelessly. It's now mandatory. And I would love to see them do so within, if I add up, it's now 60 days. That's 2 months. So I'm wishing them all the best. And if you get it right, please let Celinda know, because I think it will be, it's going to be amazing, because I've never seen it yet. People have taken forever to get their certificates. So let's wait and see how this clause is affected. With that being said, someone asked me, well, what if there's a delay in receiving my certificate? Does that mean I can't practice as a practitioner? So the Act says, as long as you can provide a proof of payment that you've applied for the certificate and you've submitted your payment, then it's deemed to be that you have your certificate and you can practice. There are penalties for failure, 125 Rand per month, up to 15,000 Rand fine you can receive if you don't apply and you're practicing without a valid certificate or any certificate at all. They've said you can't practice without such certificate. And what they've introduced now is an application made must also include a tax clearance certificate and a BEE certificate. Also raises a lot of questions for me, because when it comes to BEE compliance, a lot of companies have certificates, but for non-compliance, because they don't have to, only if you wish to engage with organs of state will you have to be BEE compliant. So the question was asked, Does that mean now that I've got 4 people in my company, all of them are white, do I need to add a black person in order to get issued the certificate? And the answer is no. The BE certificate, you get certificates issued to yourselves for non-compliance, compliance, if that makes sense. Linda and myself, we spoke about this in the week. So it's not saying now that you have to be BE compliant, and in terms of the legislation issued in that instance, it's just that you have to have a certificate as well as your tax clearance certificate. One more important thing to note, when you're applying for your Fidelity fund, a tax clearance and BE certificate only applies to entities. So that's a specific exclusion. As an individual, if I'm applying for my certificate, I don't need to provide a tax clearance or BE certificate. It's for entities like your managing agents. So I'm hoping that this doesn't cause confusion as well, because the Act isn't very specific. But again, we'll see in the coming weeks, months, how this clause will be applied and how it will affect managing agents and other entities. The next item, just on trust accounts, what the Act says is that every property practitioner / managing agent must now open and keep 1 or more separate trust accounts. This applies to entities and not individuals. So myself as an individual, I'll have a Fidelity fund certificate, but I won't need a trust account, because that is what I don't hold money in trust. The company I work for or employed by, they hold the trust account. Another requirement is that managing agents' accounting records now must be audited and submitted to the authority within 6 months of your year end. You can apply for exemption, and this is what I spoke about earlier. If you've never received trust monies or you no longer receive trust monies, you can apply for exemption. Also, if you hold funds held in the name of the body corporate, and when you do that, it's not automatic. You have to always apply for exemption. Even if you've never held a trust account, it's not automatic. You have to apply for exemption. If your turnover is below 2.5 million, you won't need to comply with the audit requirement. However, your accounting records will need to be submitted to a registered accountant and submitted as proof to the PPRA. One of the final points I want to mention, what the Act now says is that there's a specific code of conduct introduced that is applicable to managing agents. I've just mentioned a few on the slide. And because our conduct is not regulated by legislation and we have to comply, they introduce a dispute resolution process. So the code of conduct that I just want to make mention of, and generally this is what we all act like this in any event, but it's just a reminder, is to act with integrity, protect the interests of our clients at all times. There's a clause regarding specialized skill requirements. If you as a managing agent accept a mandate where a specific skill was required and you don't possess that skill, you shouldn't be accepting that mandate. However, if you do, you just have to inform the other party that this is the case. I'm thinking more maybe on a financial level. If you aren't a financial accountant, or you haven't got someone in your team that is a financial accountant and you're accepting work where this is a major part of it, it's important to inform your client of that. The next sort of point on code of conduct is if there's any willful or negligent failure to perform any work or duties by the managing agent, the client can then lay a complaint with the PPRA. This, I think, is very subjective because, as we know, clients can complain every other day that we aren't getting back to them timeously, or we didn't do something that they liked, or that they wanted a different outcome. So this one's going to be a bit tricky when it comes to laying those complaints. Another instance is if you aren't compliant with the PPA. So if a client knows you are practicing without a Fidelity fund certificate, they can then report you to the PPRA as well. Another instance, you may not divulge confidential information, which again is something we already know we shouldn't be doing. And another instance, if you receive money or reward for benefit or preferential treatment, generally when it comes to service providers or contractors. So if a client is highlighted that the MA is doing something like this, they can then report them to the PPRA for dispute resolution. And the process follows very similarly to CSOS. It's mediation. then adjudication, and ultimately an order is issued. The only difference is that the order holds the same weight as a magistrate's court order, not a high court order like with CSOS. The order can include that a fine or specific performance be ordered against the managing agent. So again, we haven't seen this yet. Let's just see. Time will tell how this will affect managing agents, what kind of disputes we will pick up that will need to be mediated and ultimately adjudicated if necessary. In closing, what I'd like to just mention, the old EAB, and I dealt with them very little, very poorly managed, and it's something that has always popped up. There's been articles and there's been court cases regarding it. So, a new name and a new authority may not mean that those long-standing issues will disappear. We aren't certain at this point, if that's the case. Only time will tell if how effective a new piece of legislation will be. So let's just see how we go, and good luck to them. And that is my presentation.
Leigh-Anne, thank you so much. I hope that everybody couldn't see me shaking my head and rolling my eyes every 2 seconds. I'm sure many of you are aware of, how our opinion has changed quite substantially in regard to a lot of government institutions, CSOS being one of them. And then, of course, we're just coming off the back end of Poppy and Pyre. I think we are all a little bit dazed and confused, and of course, quite tired of having to comply left, right, and center. And we very often think it's just one more money-making scheme, and sometimes these things are, but just like we don't necessarily agree with our government, we still pay our taxes. It's exactly the same thing here. We might not agree with what the CSOS does, we still pay our levies, we still have to comply. So from a TVDM perspective, we're going to do our best to assist you in complying. Everything that we can offer you as part of our service offering, we will do, and we'll send out information in this regard. Any questions that you will have or may have, we will deal with it as best we can. We've asked Leigh-Anne this morning specifically to keep the presentation a little bit shorter, that we can entertain as many questions as we can. And you would have seen that I've been posting quite a few on the group. We're not going to be able to answer all of them, not necessarily from a time perspective, but more importantly, like Leigh-Anne said, the legislation is still new, and things might change and interpretations might differ, but we'll answer them as best we can. So what I'm going to do, Leigh-Anne, is I'm just going to run through them from the beginning to the end, and those that we can answer, we will. Those that we can't, obviously we won't. And then what I'm going to do afterwards as well is I'm going to try to put as many of these answers together in writing, just to circulate to the owner, well, to the owners, to circulate to everybody as well. So the first question is, must an attorney who is also an executive managing agent have an FFC issued by the PPRA, ABCs, DEFs, or is his FFC issued by the LPC sufficient? Good heavens.
So the Act, or the definition of property practitioner, excludes an attorney. And if I think of myself, I'm an attorney. However, I don't practice or act as an attorney when representing my trustees or my body corporates. I act as a managing agent. Same applies to an EMA. They're acting as an EMA, not an attorney. Thus, they fall within the definition of a property practitioner, and then have to have a certificate issued in terms of the Property Practitioners Act. Okay.
The next question is, are all the staff of a managing agency required to be property practitioners registered with the PPRA? I know that you did deal with this. If you can just remind everybody of that.
So the Act does state that under the definition, it's all parties employed by property practitioners. So technically, yes. However, what you'll need to do is you can apply for exemption for those staff who aren't really involved in the day-to-day, like your drivers, like your cleaners, like you could argue HR staff both ways because they are involved with your body corporate staff. But I think it boils down to making a list of all your staff, see who's actually involved in the day-to-day, who's not even involved at all. And the important thing is you have to apply for exemption. It's not an automatic exemption.
Okay, thank you. I think this is a biggie. Is the Fidelity Fund certificate issued by the EAB already held by a managing agent no longer valid?
So if you had it issued for this year, it will be valid. However, you have to apply by the 31st of October this year for a certificate for next year. So it will be valid for until 31 December. But in order to get one issued from the 1st of Jan next year, you have to apply for a new one by the 31st of October.
Okay. There was a question about how to engage with the Property Practitioners Regulatory Authority. We don't have to deal with that one now. I'm going to send all that information out. Another question is, a scheme executive is included under a managing agent. Does this mean that trustees must also register and hold an FFC? I think you spoke about it under the self-administered.
Yes, so it's all about access to or potential access to trust monies. If you have access to trust monies, you have to have a certificate. If you don't, you have to just file for an exemption or apply for an exemption.
Along with the question as to who to contact at the PPRA, we also had a question about the EAB changing to the PPRA's banking account details. We'll get that information for you as well. There is another question. Am I understanding correctly that your interpretation is that a portfolio manager does not have to have a certificate, or if they have no access or potential access to the trust accounts, bank accounts, we then have to apply for exemption? Or because we are responsible for the client, we should have it even though we do not have direct access? We also have to open bank accounts in the names of each body corporates. I know you did touch on this a couple of times, but if you could just reiterate that again.
So if I look at myself, because I'm a portfolio manager, I deal with body corporates every day. I can tell you I've never had access to trust monies. I always instruct our accounting teams wherever I've worked to deal with that. However, I do have potential access, so it's very much an interpretation issue. And I think to err on the side of caution, I would apply for a certificate. However, I'd probably speak in conjunction. I'd chat to our whole team about it. But if you have access to trust monies as a portfolio manager, you have to apply for that certificate. Otherwise, applying for an exemption.
Okay. Here's another big one. Does the PPA also make provision for CBD points, and what happens with all of those points that were done in terms of the Estate Agency Affairs Act?
So this is a question that I do want to bring up here because I think it will open a whole nother conversation regarding the standard of training, and they mentioned the NQF4. So I think what I'd like to do is just to leave that for a separate, even if we issue an article or we do another webinar, because that's something that I myself, after doing a few webinars, reading the Act, I'm not even completely au fait with it, because it does introduce a new standard of training that's applicable to us as portfolio managers and estate agents.
Yeah.
So it's a very important question that definitely we have to address.
Definitely. For those of you that are online, if you would like a webinar, just post it onto the chat group. Alternatively, if you prefer an article, post it there as well, that we can give Leigh-Anne a bit of an indication as to her next preparation for us, but we'll definitely have her back. We've answered the question about the individual PMs quite a few times, so I think we'll leave that one. Oh, this is a nice one. As an individual PM, I can't obtain a tax clearance certificate or a BEE certificate. There is that's required for the application as a PP. Is this the same as the access for the property practitioner or the portfolio manager, rather that they need to apply for an exemption individually, or is this only for the company?
That's an automatic exemption when you're applying for your certificate, your Fidelity Fund certificate. There's an automatic exemption. You don't need to attach tax clearance or a BEE certificate. It's only for entities.
Entities, fantastic.
Yeah.
Would I'm not too sure if you know the answer to this. I definitely don't know. Would a micro enterprise BEE exemption certificate work?
So that's exactly the certificate, because I've read up on this. That's the certificate that you will then apply. You will attach to your application for Fidelity Funds, for a Fidelity Fund certificate.
Perfect. Thank you so much. Oh, this is a goodie. The issue about may not divulge confidential information. May the trustees of a body corporate be given the email addresses of owners when requested from the managing agent for a matter regarding the complex? And I think to lead on to that one, we know with Poppy and Pyre, a lot of managing agents and trustees are unaware of whether or not they still need to release information under Prescribed Management Rule 27. Do you believe, in your opinion, that this legislation adds on to that at all? I mean, does it stop managing agents from making that information available, as well as the body corporate records?
No, I think that PMR 27 will still apply, because you're entitled to release information to an owner if they're requesting same as an owner. So, and Poppy allows you to do the same as well. This is, when I look at this code of conduct, the way that I interpret it is, if you're divulging information to a third party where they aren't entitled to the information.
Perfect.
Owners are entitled to information of other owners within their scheme. As an owner, the PMR allows you that information. So in this instance, it's where you're divulging to other parties for whatever reason, confidential information. It's like me divulging information to TVDM where I haven't instructed TVDM on a specific matter. So I'm not allowed to do that. That's what I'm getting at.
Good example. We know under the Poppy and Paya manuals that we prepare for our clients that it does say that you do need to release information, to example, SARS for payroll purposes.
Yes.
Would that be something similar to that? In other words, it's
yes, so where you're complying with national legislation, or it's a requirement, it's a government or a national requirement. So then most definitely, or if you have to release information to SAPs, but SAPs and SARS, definitely you'd have to release the information.
Okay. This is a bit of a practical question, and I hope I understand it correctly. Otherwise, the person that has asked it is more than welcome just to butt in here. Is what information should be placed on the letterheads, business cards, email signatures, marketing material? I'm assuming from a property practitioner perspective and registered now previously with the EAB and all those fun things.
Yeah.
Are you able to give us some information
yes.
there?
So the Act does prescribe what needs to be on your marketing. So it's there's a registration number and your details. So what I can do is I don't know the specific list, but it is mentioned specifically in the Act. So we can make that available to all your clients as well.
Thank you so much, Leigh-Anne. No such thing as a silly question, Melissa. You said if a service provider brings a Christmas gift or chocolates to the team as a thank you, is this seen as a reward that we need to be concerned about? I'd eat those chocolates and drink those drinks very, very quickly, and then we won't have a problem.
Look, I myself have received gifts at the end of the year. I get a bottle of wine and a box of chocolates. The difference is that, we can get a thank you gift. We can give thank you gifts as well. The difference is where you're giving or receiving the gifts, and as a result, you're giving them more work thereafter. If they're taking you out and you're giving them work as a result, that's the difference, and that's where integrity comes into it. It's also very subjective, but I know I've seen it where a contractor will give someone more, take them out, give them gifts, and they only work with them, or they take a kickback. So it's important what you do with it when you receive that gift thereafter. Okay. And that's what's important. Act with integrity.
You might have said this already, but when it comes to all the exemptions that have to take place or applications that need to be made, would the managing agent company do it on behalf of its staff, or would each portfolio manager or each employee need to do that? Individual applications or one?
The Act doesn't specify who and what, but I think if I look at my case, I would most likely, the company would do it for us as a whole, obviously with maybe the help of an outside party, or outsource that application process. But definitely it wouldn't be on my own. And if I was doing it on my own, I would definitely pass by my director first in terms of the application, how it's made. We'd most likely get someone to look over it first, an attorney or TVDM or something, because it's also new to us. But definitely we'll do it as a group. We wouldn't do it as an individual. Okay. I don't foresee my employee making me do it on my own without any assistance at all.
Yeah. I'm going to take a couple more from the chat, and then I'm going to open it up from the floor, but we do still have 20 minutes or so. There's another question about the NQF and NQ5, but we'll leave that for our next webinar or article. Yeah. There's a question, thank you, Puna, for this. Any managing agent that is being formed today, what would the steps be for them to register, and where would they do that?
Well, it's all with the PPRA, Property Practitioners Regulatory Authority, but definitely you register as a property practitioner and then you apply for Fidelity Fund certificates. So the Act does sort of prescribe that, and the regulations as well. But I think that's something that, well, myself and now with Zelinda, we'll work on a step-by-step how to guide, because from the Act, I don't think it's as clear as day, but definitely if you're starting today, you have to be registered and apply for that certificate. If you're managing trust funds or have access to it, if not, you will have to apply for an exemption.
Perfect. All right. What is the deadline for this compliance?
So they've given 31 October 2022, but as we've seen, there will always be an extension. Generally, we've seen with previous legislation, but I mean, we're in Feb now. That's 8 months for compliance. So I think it does give people enough time. However, we don't know the extent of or how cumbersome this application process will be. So I could be saying that it could take a bit longer, or managing agents will struggle, but 31 October is the deadline.
Okay, and we know with Poppy and Pi that extensions most certainly do take place. So we'll deal with that when we get there. How can you apply for a certificate if you don't have a principal? I'm not too sure if you have that information for us.
I think a principal could mean, when you're talking about estate agents, so definitely not something that I know much about. I think that's something separate, because as a managing agent, I haven't got a principal. I've just got my manager and my director. So I'm not too certain how to answer that at this point.
Perfect, no worries. We can deal with that at a different time. And then the last question I'm going to take from the chat, and then I'm going to open it up for some discussion. If accountants are trainees, should this not be disclosed to the clients if they are not yet certified, but they are under management of seniors who are? I don't know if you have that answer for us.
So if I look at when you when we submit audit information to our auditors for our body corporates, there's always a question, who's the staff that you employ to manage or to assist with the accounting side? And we always have to let them know, are they trainees? Are they fully qualified? So I think it's important when you have clients to inform them, this is my team, and this one's, he's got this qualification, this qualification, this qualification, rather just play open cards either way.
So ladies and gents, I think this is, I'm getting quite excited just thinking about, how this is going to work, and the fights that we're going to be embarking on in regard to getting those certificates. I mean, imagine sending an email to them and actually getting a certificate 10 days later. I will not hold my breath, most certainly. No. And I think
really happy, but
yeah, it's if you, as long as you have that proof of payment, but I mean, things can go wrong there as well. I can almost see it as us attorneys that walk around with our little cards, holding the proof of payment in your pocket, that if anybody questions it, you're going to whip it out.
Yeah.
Now, I would like to open it up, but there's one question that I'd like to touch on quickly just from my side. The question is, can TVDM assist with the application for a managing agency that does not receive funds to a trust account, etc., etc.? So all the exemptions and registrations, all that fun stuff. Yes, I mentioned earlier that we'll most certainly be assisting you as best we can. We don't want to add to your workload at all, and we want to try to assist you as best we can. All I can say is, thank goodness I'm an attorney and not a managing agent anymore. Miss Bench that works at Pam Golding, I suppose, is now going to do what myself and Nicole would have had to do at Pam Golding, and I think we left the managing agency industry just in time to have to miss doing this for ourselves. But we'll most certainly assist you as best we possibly can, not only with the actual exemptions that are needing to be dealt with, but also with your questions and things like that. And of course, we thank you, Leigh-Anne, for your time. I know that you've spent countless hours dealing with this, and you've been looking at it for a number of months, even when it was still considered just to be a sparkle in the legislature's eye. So, ladies and gents, I'd like to ask those of you who are in attendance if you'd like to open up the floor to any questions, comments. You can use it as a rant and rave session if you'd like to as well. We're here for you, to listen to you. Over to you. Corinne, I know that you've got some questions. And Shirley, I know that you've got some comments. Just remember, you're all on mute.
Pick me, pick me.
I pick you, I pick you.
Okay, cool. So the thing is, let's say, for example, they don't perform, like the EAB didn't perform. And as a result of that, let's use, for example, okay, we now need to do a PDE4. I've already paid for my file a year ago. I still don't have my file. I've run out of time to do it in terms of legislation. They don't want to renew my Fidelity certificate. Would it be possible with them being a government institute? I mean, can you institute legal action against them? What are you going to do in a situation like that? What kind of action can you take to hold them responsible, for the fact that you cannot comply?
Yeah, I'm going to ask Leigh-Anne to answer that, but I think she's jumped away from her computer there for a second. Are you back? Okay. Sorry. What I do want to just say that I didn't pick up from your presentation that there is actually a complaints process that can be followed in regard to the PPRA not doing what they're supposed to do, but there is a complaints process that can be followed against managing agents and estate agents that are not doing what they're supposed to do. From the community scheme ombud service side, they've literally just opened up a compliance department, whatever you want, for this exact thing that you're dealing with, Hendrik. So I think that the PPRA would do the same thing in time. Leigh-Anne, do you have any answers to that?
Yeah, look, I didn't pick up on any sort of authority to deal with non-compliance by the PPA. So it will be interesting to find out how they deal with that going forward, because we know that, well, from history speaks for itself, there's going to be hiccups. So as it stands, I'm not too sure that nothing has been established, but it will be interesting to note how they're going to deal with that. I'll definitely look into it.
Fantastic. Hendrik, we're going to come back to you on that one. Yeah. There are quite a few comments and questions in regard to the NQF and the training and things like that, Leigh-Anne. So I think we need to get onto that article webinar sooner rather than later. People haven't really said if they prefer a webinar or a newsletter. Somebody has said both. I'm sure that you'd be happy to do that from your side as well. It's always nice to have something in writing to refer back to. Perhaps we could take the questions of today and do a bit of a FAQ or something along those lines and make that available on our website as well. Does anybody else have any questions or comments?
Yes, please. I do have some comments that I would.
Yes, of course.
I am looking forward to their first annual report so that I can see how much money they've got in and how many people have got registered and what they've done with the money and what they haven't done with the money. Because doing one after 5 years for CSOS in their annual report for 2021 was an eye-opener. It is so sad that we're not getting the service and we're paying so much money, and they have the ability to earn so much more because they haven't even got a quarter, it appears, of the community schemes registered.
Yeah.
This I don't hold my breath that's going to be any different, and it's just too sad for words. I've missed the link, so I'm not going to have to be have a Fidelity Fund certificate. But guys, that's more money. It's another wealth tax. It's very disillusioning. Sorry about this, but I have to be frank.
No, that's 100% fine, Shirley. This is what the platform is for. Nicole, can I just ask that you pop onto the chat Shirley's keyword access email address, that people can just contact her for a copy of that summary that she did of that report. When Shirley and I were sitting like naughty school kids in the front row on that Friday session, we decided that I was going to be the one to do the notes of the sessions, and Shirley was going to be the unlucky recipient of the 200 odd page documents that she had to review. I know that she's probably got them there, and she put together a little 12-page summary of it. And when I read it, I was like, where's the popcorn? Like, this is riveting stuff. There we go, the annual report. Quite a thick little Bible over there that Shirley has gone over and has put together a summary. If you're interested in getting a copy of that, which I really do recommend that you do, just pop Shirley an email on that email address that Nicole's going to make available to you. Guys, anything else?
Yes, sorry.
No worries, Shirley. What did you say then?
Shirley at keywordaccess.co.za, and just say if you're a managing agent or you're an owner, because I'm trying to see how much interest there is from two sides.
Perfect, perfect. Nicole's just popped your email address into the chat function there. Ladies and gents, remember that the recording and the slides of this presentation are going to be made available on our website. Please do sign up for our newsletter. Nicole has put the link in the chat function to sign up for the newsletter. If you've missed that or the January or February newsletter, please pop me an email. My email address is in the chat function as well, but I'm sure you all have it. We are going to be doing another follow-up on this as soon as possible. And what I'm going to do as well, Leigh-Anne, if you don't mind, we've got an article due tomorrow. I'm actually going to put a couple of notes together and circulate that to all of you that were in attendance, or rather through our newsletter. So if you are not signed up for that, please do sign up for it and take a look at our blog on tomorrow and early next week. Ladies and gents, we've still got a couple of minutes, about 5 or so. Anything else that you'd like to raise from the floor?
So Linda, sorry, it's Carl here. I've got a question.
Carl, how are you?
Good, and self?
Good, good, thanks.
I'm currently sitting with queries with the EAB. Who do I finish that up with the EAB or with the PPA?
You ignore all the correspondence you've had and you start your email thread from scratch, I think. Leigh-Anne, is that right?
From the 1st of Feb, the EAB was no longer, so they're definitely passing on to this new PPRA.
I wouldn't hold
start over.
Yeah.
Yeah, most likely. Good luck.
Do they have a website yet where I can check things up?
We'll post all that information, Carl.
Yeah.
Okay,
there was a question about the website, the contact details, and the banking account details. So we'll post that all. It's a sad reality, unfortunately. Any other questions, comments?
I think we're all worn out even thinking about this.
Yeah.
Oh dear. Theo, I see that you've posted your email address on the chat function. I'm not too sure what you're asking there, but if you would like to receive Shirley's report, just pop her a mail. And if you'd like anything from us, just pop us a mail as well. We don't have any other questions of the chat function. And unless there's any other comments or queries from you guys online, we can call it a day and hastily go and make a note of all of our staff in our managing agency and look at all the homework that we're going to need to do. Just a reminder that the beginning of next week, we'll send out our service offerings in this regard. Like I said, we'll try to assist you as best we can. Everything from that BEE compliance, tax exemptions, exemptions for the portfolio managers, trust accounts, and all the rest of it. Unfortunately, it is something that needs to be done, and we know how quick the time flies. We might be sitting at October any day now. Oh, October, that's an interesting date. It rings true to 5 or so years ago when the Sectional Title Schemes Management Act came into place. It was a month that I don't think any of us will forget very quickly. So there we go again. Ladies and gents, anything else? Going.
Thank you for always being relative and up to date and relevant. I mean, not relative, that too. But thank you so much. And thank you, Leigh-Anne.
Fantastic. Thank you so much, everybody. Have a fantastic day. Have a good weekend. It's almost Friday. Don't let all these things stress us out too much. We'll get through it all. We'll get through it together. Keep well, everybody. Have a lovely day.
Bye, Leigh-Anne. Bye, everybody.